So workplace privacy doesn't work the same way as privacy in a purely personal setting. Hello everyone and welcome back to Privacy Professional Training. My name is Fumi Owolabi and I'm the founder. In today's video, we're going to be moving into domain 4 of the CIPPUS, which focuses on workplace privacy. So I've been doing a series on the channel discussing the different domains for those that are studying for this exam. And essentially, this particular domain looks at privacy issues that arise through the employment lifecycle. And this includes what happens before someone's hired, while they're employed, and after the employment relationship ends. So workplace privacy can feel very personal because it touches on monitoring, background checks, investigation, and employee records. At the same time, it's heavily shaped by US laws, which often requires the balancing of employee privacy against employer interests. So if you've watched any videos that I've done in the past, you know that a data subject is an individual that can be identified. But within a group of individuals, there are clusters. There is the employee cluster, there is the vendor cluster, there is the customer cluster. Each cluster is anticipated. This particular cluster is going to be the employee cluster. As we go through this domain, I want you to focus on understanding where privacy expectations exist, where they're limited, and why, because those are going to come up and assist you when answering questions throughout the CIPPUS exam. Now, this perspective makes this material much easier to work through. So the first thing we're going to look at are core workplace privacy concepts and governance, and this is covered in this domain. Let's start with the foundational ideas that shape workplace privacy in the United States. So workplace privacy doesn't work the same way as privacy in a purely personal setting. In employment relationships, privacy expectations are often influenced by notice, policies, and the nature of the workplace itself. One of the most important concepts to understand is appropriate expectations of privacy. This concept asks whether it is reasonable for an employee to expect privacy in a particular situation. Now, it's really important to understand concepts in a privacy setting because they might mean something outside of the lay understanding. In addition to this, anti-discrimination laws also intersect with workplace privacy. Laws such as the Civil Rights Act of 1964, the Americans with Disabilities Act, and the Genetic Information Non-Discrimination Act influence how employee information can be collected and used. These laws help explain why certain types of data are especially sensitive in employment contexts. So understanding the discrimination and which of these laws apply in a specific scenario is going to be key as you continue with your studies with this domain. Workplace privacy in the US is also shaped by regulatory oversight. Several agencies play roles in this area depending on the issue involved. These include the Federal Trade Commission, which we also covered in Domain 1, the Department of Labor, the Equal Employment Opportunity Commission, the National Labor Relations Board, and the Occupational Safety and Health Administration. Each agency approaches workplace issues from a different angle, which contributes to the complexity of this particular domain. So when we looked at Domain 1, we looked at all of the regulatory bodies that could be in place related to a specific law. This workplace privacy domain is no different. So you need to see which regulatory body applies to which law. Now let's walk through workplace privacy issues in the order they often arise. Let's look first at pre-employment privacy issues. Privacy questions often begin before employment even starts. Employers may collect information during the recruiting and hiring processes. This information can include things like background checks, screening tools, and application materials. Automated employment decision tools are increasingly common because of artificial intelligence. These tools can raise concerns about bias and transparency. And understanding that these tools exist and raise privacy and fairness issues is important during your studies. Background checks may involve criminal history, credit information, or education verification. Some screening methods go further, such as personality assessments or psychological evaluations. Other practices include polygraph testing, drug and alcohol testing, and social media monitoring. Each of these raises different privacy considerations, so you're going to need to be able to make a distinction when you're reviewing questions. In addition to this, unionized workplaces add an additional layer. Privacy issues in hiring may intersect with collective bargaining rights. That context can influence how monitoring or screening is perceived and handled. So you need to be able to understand the influence of unions and what type of laws are associated with how personal data can be processed in these contexts. Let's move to privacy during the employment period. Once someone is employed, privacy issues often shift towards monitoring and oversight. Employee monitoring can take many forms, especially as technology evolves. Monitoring may include computer usage, internet activity, and social media access. Some workplaces use biometric systems such as fingerprints or facial recognition tools. Location-based services may be used to track devices or vehicles if that's required by the organization. Something that's become more frequent in the workplace are wellness programs that can involve sensitive health-related information. So you need to be able to make a distinction between the types of personal data identifiers too here. And the first law we're going to take a look at is the Electronic Communications Privacy Act that plays a role in employment setting. It helps explain how employer access to communications may be treated under federal law. Another important area involves internal investigations. These may arise from employee misconduct, policy violations, or complaints. Investigations often require collecting and reviewing employee information. Some of the privacy issues that might be discussed here include information that is gathered and how it is handled. Third parties may sometimes be involved in investigations. So looking for things like documentation of performance issues can also raise privacy concerns here. Employers must also consider the rights to multiple individuals at the same time. When doing your analysis for your review of the CIPPUS, you need to be looking at balancing fairness, confidentiality, and transparency, because these situations are going to highlight how privacy questions often involve competing interests. Let's take a look at post-employment. Workplace privacy doesn't end when employment ends. Some post-employment issues that may be reviewed during the exam are termination processes and transition management. Records retention becomes especially important at this stage. So making sure you're looking at different parts of the question that address how long a record is retained, what types of individuals and at what stage an employee is in the workplace privacy arena, whether it's before they're employed, while they're employed, or after they leave the company. And understanding the privacy obligations and expectations extend beyond active employment helps complete the picture of this particular domain. So with respect to this video, workplace privacy is a wide-ranging domain because work touches on so many different aspects of personal data. Domain 4 here asks you to understand how privacy principles apply before employment, during employment, and after employment ends. It also asks you to recognize the role of notice, expectations, technology, and oversight in shaping workplace privacy, and how the laws interact with what an expectation is that an employee has against the competing interests of an employer and their obligations under different laws. If you approach this domain by thinking through the employment lifecycle step by step, it becomes much easier to follow. In the next video, we'll move into state privacy laws, which add another important layer to US privacy regulation. I hope you enjoyed this video. If you like this type of content, subscribe and I'll see you in another video.